Okay, well, that's my green light. So thank you, Aviva, so much for scheduling and for all that you do. My name is Robert Schwartz. I am thrilled to be here today, this afternoon, and I welcome everyone. I've seen now some friendly faces, some new faces, and I really appreciate everyone logging in for a discussion about mediation. I am primarily a commercial litigator. I have practiced in the Chicago Loop for more than 30 years. In fact, I've been on the South Street for more than 30 years, different addresses, but I've been on LaSalle Street practicing primarily commercial litigation for that whole time. It's not a secret to people who know me, to my clients, and frankly, opposing counsel that I either, I'll say bug or bother. They might say something else. I hope that I have become, and it's also a cliched word, passionate about mediation. As we go through the next 45 to 50 minutes or so, I hope you'll understand why and possibly also appreciate the process, the methodology, and consider it in your practice or promoting it to your clients or colleagues. There were four handouts in PDF format that Aviva had sent out. I'm going to be following the outline that I prepared. The others are first the statute. Illinois has adopted the Uniform Mediation Act. It can be found at 710 ILCS 35. And I forget how many other states have adopted it. It is much like the Uniform Arbitration Act, a guidepost and procedural rulings for how to conduct mediation. And so I strongly urge, and it's only, I think, 4 pages or so as codified. So it's relatively brief. Shockingly, Springfield narrowed it down. And so it's 4 pages. I would urge everyone to read through the Uniform Mediation Act. That was an attachment. So first, let's talk about what is mediation. And let's also talk about, almost more importantly, what it isn't. The definition as provided in the Act and in my outline is that it's called a confidential, and now I get to talk with my hands, which I enjoy, if everyone's okay with that. Confidential, informal, non-adversarial, and non-binding process in which an impartial, neutral third party, which is the mediator, facilitates communication and negotiation between parties to try to achieve a resolution. Now, I added in the definition a methodology. And the question is, well, why would you add that word to the definition? And the answer is because of misperception and misunderstandings about the definition I just provided. Most people think, and it's understandable why, that this is merely a more formal version of negotiation. And that's very understandable. After all, let's assume that there is a lawsuit pending. We'll talk about civil litigation exclusively. Civil litigation is either pending or about to be commenced. Two opponents start talking, and now I get to use my hands again, at, over, around, and under each other. And I would challenge anyone who has a spouse, child, a parent to talk to, at, around your child, your spouse, your parent, and convince them that you are right. That is negotiation. And one of the best pieces of advice that I've ever received in my life, and could be right, could be wrong, I don't know, is you could either be right, try to convince somebody of that, or you could be effective. So what I'd like to impart today also is to be effective as a litigator, to strongly consider mediation and be effective, as opposed to merely having an adversary to whom you're talking at, over, around, and against. It is rare that you will convince an opponent, an adversary, of the rightness, correctness of your position, as an advocate at least. So in this process where there is a neutral mediator, absolutely impartial, there is an additional component that I think is invaluable. And this is, again, why I've become very passionate about it, because this process imparts to the civil proceeding an element that I believe cannot be found anywhere else. There is also some confusion with, and here I bring up three more types of alternative dispute resolution: litigation, arbitration, and, as I just mentioned, negotiation. So how is it different from those three things? Well, I just discussed for a moment, and I hope I covered this. Negotiation is sometimes, and again, pardon my hands, like this. So we have now a third-party neutral that imparts an element that we're going to talk about in a few moments. So it is different than negotiation. Yes, it does involve two parties that are effectively negotiating, but in a collaborative process with a third party. So it is distinct from strict negotiation, which is also very important. And I also would urge my colleagues in civil litigation to do something that really doesn't happen enough. And that is, again, pardon me, this telephone, or this Zoom, or even better still, in person, live, face to face communication. I have been almost shocked with the number of times that I've had an opponent, an adversary in litigation, and maybe there's been motion practice for a year, possibly even longer. And at a certain point in time, whether it's a plaintiff or defendant, I have reached out and asked the opponent, what does your client want? What do you want? You might be shocked. You might be surprised. You might just get it. What do they want? And I've been very surprised, disappointed actually, that the opponent says, gee, I'm not sure. Okay, well, it's not a challenge, but it's a request. Could you go to your client, as you're ethically required to do, find out what they want, especially at this juncture, whether it's after a year, a month, 2 years of motion practice. What does your client want? That's absolutely crucial, I think, in negotiation. What does your client want? What do they need? What would they consider? How can we get there? So I'm taking a step back and talking about the negotiation process. If there's an impasse, again, this is where I would urge mediation. Litigation itself, we know, is very formal, strict proceeding, and we probably have the least bad system in the entire world that's ever existed in history. Here in Cook County, where I practice, here in Illinois, and here in the United States. While there's a lot of criticism, it's my belief, and from journal articles that I've read, and I'm not going to start debating or discussing this with anyone, but I still believe it's the least bad, if not the best system that's ever been created. Having said that, litigation, we all know, is exceedingly expensive, time-consuming, and emotionally and psychologically, if not physically, sometimes even medically draining. So mediation offers an alternative to that. Arbitration is another form of alternative dispute resolution proceeding. And it was, as we know, initiated by very, very well-intentioned, very, very well-meaning, and scholarly judges, lawyers, law professors, and business people who thought that there could be and should be a more efficient and effective methodology. And that is arbitration. However, in arbitration, an arbitrator, as we know, issues a ruling, an opinion, or a decision. And in mediation, the mediator does not, and I think this is very crucial, and it's critical for clients to understand and for practitioners to understand, the mediator does not render a ruling, opinion, or decision. A mediator does not make a finding of fault or liability. They do not assess damages or liability. The mediator's role as a neutral is to assist the parties, to facilitate communication so that they can explore alternatives to continuing on in litigation. And the mediator should, and again, now I can use this, sharpen a pencil or pen to pinpoint, navigate, and define needs, wants, mutual interests, to reassess goals, and those are the elements. Those are the things that I think can bring parties to reach a resolution. Uh, the participants may have noticed that I've used the word resolution rather than the word settlement. Now, we do understand that in litigation, uh, most cases do settle, and in mediation, the end result oftentimes is also settlement. So certainly that is the goal, but I like to use the word resolution, at least in my practice, because it seems to be more encompassing. I very oftentimes tell clients, and again, maybe they're uh, bothered by it. Typically in litigation, you will not get a great result. You just won't. Even if you win at trial, the other side might appeal. Even if you win at trial, you might not collect. So it's rare that you can get a great result in litigation. However, it is very common that in mediation, you can get a very good resolution. And I think one of the most effective tools that I heard a mediator say when I first came into this arena, this field a decade ago, was a mediator asking me as an advocate in mediation, let's bring your client in, ask your client, how will you feel tomorrow morning if you are still embroiled in litigation? I've been told that by a marketing person, sometimes they try to get work by asking a potential client, what keeps you up at night? And litigation certainly keeps people up at night. How will you feel if you can resolve the litigation today here? Not to say that it's always easy, even in mediation, but tomorrow morning, how will you feel looking back and having the matter resolved? I think it's an effective tool, and again, I think it is one of the most compelling aspects to mediation is that there is going to be finality. Again, even at trial, there's always a chance of appeal. There's always a chance of non-collectability, and mediation offers that finality that many times I believe brings out that compelling aspect of how will you feel tomorrow morning. So let's talk about now some of the elements and components to that definition. So collaborative, the Uniform Act describes it as being very adversarial society, culture, and profession. Uh, the adversarial nature is actually the definition of litigation. Well, collaborative, as part of the definition of the Uniform Mediation Act, requires that the parties work within a certain framework, not defined as adversarial. So typically, the decorum required by a mediator is to avoid words, emotions that create an adversarial, if not hostile, atmosphere that usually permeates through litigation. So there's the collaborative nature. The next is the literal and figurative forum. Mediation occurs typically, it could, but it usually does not occur in a courtroom. It can occur in a mediator's office, in a lawyer's office, any space that the parties ultimately agree to. So again, parties typically do not feel the pressure, if not stress, of being in a courtroom. There's a cliche that's entered into our culture, safe space, safe place. Well, mediation is exactly that, as defined not only by the Uniform Mediation Act, but by the practice engaged in mediation. It's a safe place to safe space. Parties are assured, and there's case law that I attached, that what occurs, I think they used to say in Las Vegas, what occurs in mediation stays in mediation. The case that I attached not only it defined mediation communications, but made it very clear, clarified that the act protects, much like litigation protects communications, the mediation forum protects communications made in anticipation of the mediation itself. So communications with an attorney in preparation for mediation, communications about the mediation that is about to occur, those are protected. Those are inadmissible. If mediation does not result in a settlement or resolution, as I called it, those communications are inadmissible. They're protected under the Act. And I think it was Judge Shader who gave a very stringent and robust discussion and opinion about protecting those communications. It's not merely the occurrence in the forum, but even the communications revolving around it in anticipation of it. So parties should feel confident, they should feel comfortable that they're in, again, I hate the shade word, safe space and a safe place. The forum also typically lends itself to what we call shuttle diplomacy. Parties in one room, one party, plaintiff typically in one room, defendant and their counsel typically in another room, separated from each other. Again, not necessarily because there's so much hostility that they can't see each other, but again, because they can communicate directly with their own clients and feel like that there is, if not only just a physical separation of space between their adversary, but that they have, I guess, a cocoon of comfort around themselves. So that's the forum. And again, it's unique, and I believe it offers confidence to the parties in order to facilitate that type of communications that are productive and ultimately reaching a resolution. The next aspect, or next element that flows from that is that parties elect their own fate. And this is something that when I'm conducting a mediation, if it's not the very first thing I say and explain to parties, it might be the second thing. And that is, you're not going to be worrying about what does a judge or jury think. You're going to create your own fate. And I believe and I hope that parties feel empowered by that. So that leads into the next aspect, which is, I think, overlooked again in litigation. Mediation should parse out dispute, my hands, if that's all right, dispute and conflict. A dispute typically, as we know, is the substantive issues that are pending in litigation. Was the contract breached? If so, what are damages? Did the party cause damage? If so, what are damages? What usually does not come out in litigation, and many times actually is not allowed to be brought out in litigation, is conflict. We live in an age where I think, for better and worse, I think more for better, there's more awareness about mental health issues and psychology. Well, psychology in litigation should not be brought to the forefront. But here we have the two examples I gave. Breach of contract, for example. You know what? Last time we had that contract, they got the better of me. This time, I'm going to get one over on them. That might be existing in the ether of the case. That's a conflict that does not come to the forefront and can't usually get resolved in litigation. I can't believe that person hit me with their car. They didn't even apologize. They didn't even say they're sorry. They didn't even ask how I was doing. Well, that's not part of the dispute in a personal injury lawsuit. That's a conflict. That's an emotional, psychic, if not psychological burden that is weighing on a plaintiff, for example, and is not usually resolved. While it might be addressed by pain and suffering damages, it's not something that typically is an element of the litigation itself. It can be addressed by damages, but it might be an element that is preventing a resolution within litigation. In mediation, A party in their safe space, in their safe place, gets an opportunity to do something that they cannot in litigation. They can talk directly to the mediator. You can't talk to a judge. You can't express your feelings, your emotions, your psychic burden to a judge. Yes, an opening statement, a closing statement by an advocate, by a lawyer, might express that to a jury. That's years down the road. In the mediation forum, you have an opportunity, one has an opportunity to speak directly to the mediator. And then the mediator knows, should know, here is an obstacle. Here is a psychic or emotional or other type of obstacle that is existing in the ether that's a conflict preventing a resolution, separate and apart from the meat or substance of the dispute itself. So that's another unique feature of mediation that is not afforded in litigation or in arbitration. So moving down my outline, and with all these benefits, why is mediation then not utilized more often? So I've identified a few, and I've looked through a lot of journal articles, and I could distill it down to a handful um, of objections why mediation is not utilized more by litigators. The first one seemed to me a little bit counterintuitive. But then the more I thought about it, and the more I thought about my own experience with it, and I'll share a war story if no one minds, is unfamiliarity. So because most litigators had trained in law school and then as an associate or in a public office in litigation, mediation is a skill set and a methodology that typically was not introduced. So litigators might simply be unfamiliar, and we're human beings. Ego. So now the war story. I had proposed mediation to an adversary in another state. It was a fairly significant matter. The other lawyer refused initially, without even further discussions, just an offer to mediate, and the lawyer refused. Again, being annoying as I might be, I circled back in the next phone conversation and introduced it again, and I suggested the following. We know that there's an ethical requirement that if there's an offer of settlement made, the attorney has to go to their client, right? I said, I'm suggesting something, and I feel like maybe you should at least run it past your client and circle back and let me know if you and your client are still firm on rejecting that process. And there was a pause, and the attorney said, following, well, I didn't consider mediation to be an offer. I don't really know what it is. And you know what, Robert? I'm just not familiar with it. There's the unfamiliarity. So let me at least look into what it is before I present it to my client and let them know what might be the benefits, upside, downside, cost benefit analysis of going through that process. That session, admission, I'm not sure what to call it, I actually really respected. And I told the adversary so. Again, he was out of state. I said, you know what? I appreciate you letting me know that you're unfamiliar with it. And in fact, let me send you a few links, including the Uniform Mediation Act, and it was also adopted in that adversary's state. It's adopted in your state. You can choose the mediator if you want it to be in your jurisdiction, for example. Now, jurisdictionally, we'll have to follow certain laws of particular jurisdiction where the case was pending, but you can choose the mediator. If it's somebody that, and I'll vet to see if they're qualified and truly neutral and all that, that's fine. But please, dear advocate, dear opponent, dear sworn enemy, understand that this is a process and a forum in which we can reach resolution, because these parties were really antagonistic. And ultimately, that attorney did go to do some research, went to their client, came back, and we did have a successful mediation. Successful in the definition that it did reach a resolution and finality. So we're humans. We have ego. We don't want to admit or be embarrassed that we're not familiar with this methodology in this form. I've heard mediation's expensive. Mediators are typically former judges. Well, that carries a lot of credibility, and it carries a lot of weight, and they are entitled to and charge typically a very high fee as mediators. So if you think mediation is expensive, and I hate sound glib about this, but if you think mediation is expensive, and again, I've tried to gently challenge adversaries. You think mediation is expensive, try litigation, and I'll leave it at that. One of the biggest objections, and this is more understandable to me, is discovery. In litigation, we know that not only can you compel or require discovery reasonably from an opponent, but you have subpoena power. So powerful tools in finding out the information that you need to promote your cause in your case. I think, biggest objection, and the one that I think is most understandable, is that litigators feel that once I'm in that mediation forum, I cannot then find out if there's a smoking gun out there, and I might have missed it. And the discovery that I have right now, by the way, I've already got a slam dunk. Now I use both quote marks, right? Slam dunk. If you had a slam dunk, your case would have been settled already. I think it is exceedingly rare that there is ever any such thing as an absolute slam dunk, and that discovery would disclose that. In fact, if you did have a slam dunk, you would have either already received summary judgment or a concession or settlement from that other side. And the fact that you haven't, your posture right now, almost by definition means you don't have the slam dunk. It's probably a good time to consider mediation. Overlooked, I'm sorry, at the very outset was mediation can be commenced at virtually any time. It can be commenced before a lawsuit is filed, assuming you have, contact with an opponent. It can be commenced after the filing of the lawsuit. And I think litigators might be surprised to know that even after an appeal is pending, so for example, the Seventh Circuit now has a program, after appeal is pending, there is a mediation program, which is encouraged, by the way, within the Seventh Circuit. And I don't know other jurisdictions, other circuits, but the question would arise, wait a minute, there's been a verdict and there's an appeal pending. We're waiting for a ruling from the appellate court, and that should really finalize everything. That should give us a determination of whether the lower court was correct or not, and that should resolve everything. Why would there be an encouragement to consider even mediating after the filing of an appeal? And I believe and I hope that the answer has been what I've been saying for the last 20 minutes or so, that the forum, the nature of the proceeding, the nature and methodology of mediation means that even after an appeal is filed, the parties still have a very, very good chance of reaching a resolution. I don't remember the exact statistic, but I feel like it's somewhere in the mid to upper 90 percentile that if two parties willingly come to the mediation forum, there will be a resolution. I think it was somewhere between 93 to 97% of matters that voluntarily enter into mediation result in a settlement. Now, that
Rob, I think we lost your audio. Rob, we've lost your audio. Can you hear us? Hey, I'm trying to get this to Rob that we are not able to hear him. Okay, it looks like he's fixing it, everyone, so just hang in there. Try to say something, Rob. Let's see if we can hear you. Okay. Thank you, everyone, for your patience. Okay, Rob, you should be able to unmute yourself now. I just made you co-host again.
Can you hear me now?
Yes, thank you so
Okay,
much.
I am so sorry. I apologize for that. I guess I'm just, so the new technology for an old dog like me, I apologize. Um, I think I lost audio when I was talking about the challenges and objections to mediation. And I was discussing that litigators sometimes oppose going to mediation because they fear losing discovery, the ability to continue to issue subpoenas, to continue to take depositions, to continue to follow up and procure documents. And that, I believe, is actually an understandable objection. Um, how can we overcome that? What is the reason that that objection, which is well founded, what is the reason that that objection could be overcome? And I think the answer is, again, the forum, the the methodology itself lends itself to a very, very open, honest, and robust communication with the mediator. So when a party is in the room caucusing directly with a mediator, this is an opportunity that that party can disclose not only the strengths and merits of their own case, but we all know there's always going to be some warts. I think before I lost audio, I was saying, if somebody heard, that there is rarely any case that ever exists that is a slam dunk, right? So a honest and open litigator will concede certain facts, as they should, to the mediator. And that's where a mediator, a good mediator, can bring some confidence to the situation and let that litigator know, hey, thank you for sharing that with me. I cannot and will not, and if you see my outline, as well as the case law, mediator cannot share that with the other side when they go back into the other room, unless the party wants the mediator to share that. So while reaching the point of getting into a mediation session means that effectively discovery is cut off, it doesn't mean that you can't disclose to the mediator certain facts that either are exceedingly meritorious for you or a wart, as we might call it, maybe not so helpful, and why and how it is that at this point, because of that maybe not so helpful fact or legal issue, that you at this point might want to reach a resolution. So the discovery objection is probably the most well-founded one that litigators have to prevent them from seeking out mediation, as we call it in Chicago, early and often, right? And I do see a chat, and that is true. So thank you, Mike Jordan, for that comment. That if everyone sees that comment, that is absolutely true. Mediator can help. So that's another aspect, another benefit through the process that helps overcome the objection that litigators might have concerning discovery. So now that we know the benefits, which I think are so vast to mediation, let's talk about the process itself. I've already discussed the fact that it could be initiated at virtually any time, even before the commencement, the filing of a lawsuit, and even after a verdict and in an appeal process. Has there ever been a mediation that occurred after appeal, after a final verdict? And the answer is yes, even after a final judgment, so to speak. There's again issues of collectability, and there are some journal articles that are very interesting about mediations that have occurred after a final appeal, and there was a resolution reached even at that late stage. The process usually is initiated again, litigants, litigators reaching out to each other and discussing that possibility, the logistics, and the terms. So once it's agreed that this could be a good process, we need to pick a mediator. Well, there are hundreds, and I don't have the statistic here, but there are hundreds of highly qualified mediators. Two of the most common fields for mediation, one is somewhat intuitive, is in the called domestic relations. I think the more appropriate would be in divorce. In the divorce world, there's many good mediators, and that is a very common field to mediate. And again, the reason is quite apparent. These are people who are very emotionally invested, very financially invested, and sometimes so much so that they become entrenched. Litigation would be very daunting, very expensive, and very time consuming in that field. And so mediation lends itself very well to that. Labor and employment relations. Again, the investment that an employee and an employer have, much like a marriage itself, the entrenchment and the emotions run high, and a mediator and mediation process brings oftentimes resolution that could not be reached as readily through negotiation or ultimately possibly even litigation. So selecting a mediator, the two parties should be able to agree based on the many available mediators who are there, list their credentials, their backgrounds. I would suggest that a mediator be chosen not so much because of the perhaps high status that they have, but more so because of the Thank you again, Michael. That's true. Emotions everywhere. And I think that was something I discussed at the outset. So, again, another advantage of mediation. Um, I would suggest that litigators choose a mediator based on typically field of practice. So, divorce lawyers typically go to. There's a subset of divorce mediators, which makes a lot of sense. Some, and I hate to say this, but some very high status mediators might not be effective. There is rarely a correlation. Sometimes there is. Ask around. Ask former former litigators who had mediation with a particular mediator, what was their experience? Now, obviously, they can't tell you what occurred during mediation. I think what you're looking for is to find out, was that mediator effective? Was that mediator empathetic? Did they listen? Did they hear? Did they perceive, discern, and understand the issues? One of the first things a mediator ought to do, I suggest, is get to know. There was a rule for used to call them stockbrokers back in the day, the know your client rule. Know your parties. A very good mediator ought to not only introduce themselves first, but then find out about the litigant. What is your goal? What is your realistic assessment of your likelihood of prevailing? What is your need? What is your want? Again, two separate things. Like we said, there's dispute and conflict. There's a need and there's a want. A need should be met. Sometimes the needs during the course of mediation get reassessed and realigned because of exposure to certain facts that might come out. And again, I think a good mediator should be considered someone who is empathetic, listens, and hears. And by the way, there's a difference we know also between listening and hearing. One is active, and that's what we want from a mediator is to hear the parties. Parties want to be heard. We know sometimes some of the complaints we hear, or I should say grievances we hear amongst litigants in the court system is, the jury didn't really understand. They didn't hear me. The judge didn't hear me. So look for a good mediator who will hear a litigant, be understanding without expressing an opinion or a ruling. Again, we've talked about, I think briefly we touched on logistics. Parties can agree where the mediation should occur, whether it's in one of the lawyer's offices. Not surprisingly, I've had a few times where my adversary was absolutely adamant the mediation has to occur in my office. I need the home court advantage. I need the home court advantage, and we can't do it anywhere else other than in my office. Okay. Remember, the process and methodology means there ought to be no such thing as home court advantage. There ought to be and needs to be absolute neutrality, especially by the mediator. Aviva, can I ask you how we're running on time?
Sure. We've got probably another, well, if we want to leave some time for questions. We've got 15 minutes left, and probably let's leave about 10 minutes for questions.
Okay. So after we've chosen a mediator and some of the logistics, time, place, accommodations for the session itself, now we enter into the proceeding or the session. A mediator ought to hold first an initial pre-mediation session. This is an opportunity that I would suggest that the lawyers only participate. The two sets or more, however many there might be, there could be multiple parties, obviously. Without parties, that the lawyers confer with the mediator so that they can learn the mediator's style, what the mediator is looking for, what the attorneys are looking for. So that can be, typically it's Zoom these days, used to be in person. That initial pre-mediation conference, I think is very crucial to getting, let's say, we'll call it a taste for what could be encountered at the session itself. So a good mediator will have that pre-mediation session to get to know the lawyers. Again, I think it should be without the parties. And expectations should be expressed. Next, typically there is a submission made to the mediator. I recommend and advise that most pre-mediation submissions be confidential. That is, not be shared with the other side. Why? Because most typically you've already been engaged in motion practice. We've seen your advocacy. We know your position. We know the law that you believe applies. We know the facts you think are salient and relevant and most significant. We already know that. We know how you're advocating and why you're advocating. So rehashing that to the other side in a pre-mediation submission and sharing that, I believe, is a negative and can only usually inflame or incense the other side. There are some occasions where a pre-mediation submission should be shared, and litigators might agree to do so. And that is when there's some new or important either law or information that exists that hasn't been involved in the dispute. So there are occasions where that should be shared. And again, that pre-mediation initial conference, a mediator could advise that, and litigants would be wise to heed that suggestion from the mediator. The pre-mediation submission, assuming that it is confidential, going only to the mediator, should not be, and this is where I think litigators fall into a little bit of frankly, a trap, which is very understandable. They often treat it as a new motion or a new pleading. Hey, now I get to freshly bring in and submit to the mediator my position. We started at the beginning talking about the definition for this form and this process and this methodology, and it is considered to be and should be non-adversarial. Now, that doesn't mean weakness. It doesn't mean loss of advocacy. What it means is presenting a mediation submission that is candid, forthright, and open. So it should present to the mediator, first, obviously, the law that is applicable. It should already include copies of the pleadings, discoveries, disclosures, but the body and text, the body of the submission should indicate to the mediator what is expected to be the result or resolution of the session. And again, here we're talking about, I think, wants and needs. So I think it's imperative that the wants, needs, and maybe it goes against our grain, disclosing the warts of the case. The other side won't see it, again, assuming it's confidential. The mediator will and should assist in overcoming the fears and concerns about disclosing the warts. They're going to come out anyway at trial if it goes forward. If it didn't go to mediation, it's going to go towards trial and it'll come out then. Why not get it out early, as we say in Chicago, early and often and up front? In addition to disclosing some warts, obviously what should be highlighted is the strengths of the case, so the mediator knows what would be promoted, what would be propounded most vigorously if litigation were to continue forward. So that's the pre-mediation submission. It gives the mediator the pleadings, the discovery that's already occurred, and it gives the position and posture. It gives the position and posture of the party so that the mediator, again, can now in reading, so now at the session they will hear the litigant. This gives them an opportunity beforehand to read and see firsthand the strengths, weaknesses, wants, needs of both parties, or if there's more than two, of all parties, and utilize that to try to reach either a consensus or at least an understanding. So again, the forum itself and the session itself, let's talk about that. So we've prepared for the session with the pre-mediation submission. You've prepared your client. The mediator now will introduce themselves, and they will express what I think is one of the most fundamental aspects of this: trust. Trust in the process, trust in the mediator, and ultimately trust in trying to achieve a resolution. So a good mediator, again, will engender that trust by reminding the parties again about the inadmissibility, confidentiality of the process itself, the ultimate goal of reaching resolution and facilitating communication. So again, I almost can't emphasize enough how important it is that a mediator try very hard to engender trust with the parties and with the litigators in themselves and with the process. And my experience personally, and I'll look for some chats on this, is if trust is there, we might even call it faith. Uh, Usually that leads to, again, open, robust, and truthful communication, which could not usually be achieved in the litigation or arbitration process. In terms of those goals that we talked about, the wants and needs, again, I'm often surprised when I ask an opponent, hey, what does your client want? And, well, I'll go find out. Well, what are we doing here? What have we been doing for the last year? Most parties, most litigants will say they want to win. Our society, our culture prizes winning. Well, how is that defined? Does that mean winning, obtaining, procuring just only money? I've been surprised also to see, and maybe some of you have as well, sometimes a party wants an apology. Sometimes a party wants to reconvene a relationship. One of the most interesting and surprising mediations I conducted was involving a distributor, a supplier, manufacturer, multi-parties. It was somewhat complex. And at the end of I think it was 3 or 4 full days of mediation, the parties entered into a new distribution agreement. There was, again, that overriding ether of, well, they got the better of me last time, I'm going to get them this time. That's why we're here. That's why I filed the lawsuit. Well, let's try to be productive. Let's rethink and recalibrate. What is it that you really want and need? Well, I needed that distribution channel. I needed that supply chain. Okay, is there any possible way, despite the bad blood, that we can hammer something out? And they did, and it was very gratifying. Those types of wants and needs, again, virtually never come out in litigation because why? It exposes an emotional, psychic, intangible expression that frankly doesn't belong in litigation. But here's a forum where it could be expressed and could achieve for the parties a resolution. Again, not necessarily even a settlement, but a resolution where the next day, if you ask them how did they sleep that night, the next day they might feel that they're better off. So this is an opportunity to assess wants and needs in a form that doesn't exist in litigation or arbitration generally.
Excuse me, Rob, I think
Yes.
Mike Goldstein, did you have a question? Are you raising your hand? You can unmute and ask your question if you have a question.
Okay.
Okay.
See that in the chat. So before this CLE, I asked Aviva if it's generally if we do questions at the very end, or if we, and I'm not sure if I use this correctly, pin or bookmark, but that is such a great question. I'm going to try to address it now if I can. And Michael, if you want to come off of mute at some point, if Aviva lets you, we can discuss this. The question is, how do you avoid buyer's remorse? And again, I think one of the very gratifying experiences that I had was, again, about maybe almost a decade ago, where it was a much more experienced mediator, and I was acting as an advocate in mediation. And the question was posed again. I come back to the salesperson question or the marketing person question approaching a business person. And I've asked this of extremely, like wildly successful business people. Hey, this is you're doing terrific. You're doing so well. I'll try to answer you anyway. Um, and I'll get to this question also. Um, thank you. So again, the very experienced mediator, when I was an advocate, posed the question that I had heard posed to a very successful business person. Hey, you've got all these great things in your life, in the business world at least, right? What keeps you up at night? And then surprisingly, the business person tends to say, oh, well, it's this and it's this. And oh my gosh, I thought you had everything wrapped up. So how do you avoid buyer's remorse? And the answer is, which I was starting to get to, at the end of the session, if you reach a resolution, the terms are, as Judge Jordan knows, reduced to writing. Let's make sure, I think, to try to answer your question, because there could always be some buyer's remorse. But let's try very hard to address not only the wants, needs, and issues that were in the litigation, but let's see if we can't do exactly that. What would keep you up tonight if you resolved it with this way? Oh, well, you know what? I still want that apology. So I was actually getting to that last point now about reducing, if you reach resolution, to writing, memorializing it. The parties should be the drafters. Again, somewhat counterintuitive. Typically, it's believed that the mediator sharpens their pencil and drafts up the terms of the resolution or settlement. It's typically better to enable both sets, in my view, both sets of litigators to draft up those terms. And I think an effective mediator, and Michael, I'm not sure if you do this, is okay, here's the terms. There was I was learning to take depositions. I thought it was silly. Is there anything else that I should be asking you? It seemed like a really silly question at the time. And during previous war, there was someone who was laughed at. They said, well, we know what we know. We know what we don't know. And then the third statement that that person made, everyone laughed at the time, but I thought was actually now very salient. And it's, we fear what we don't know. We don't know what we don't know. Well, obviously, right? And it seems silly, but now in retrospect, it's okay, what else is out there? What would keep you up at night? What would create buyer's remorse, or tomorrow morning that you have regret? Let's get it in there. At that point, Judge Jordan, respectfully, if you've done that as a mediator in your role that way, and you've addressed those potential remorseful or regretful issues, I think you've done everything you can. And it would go back to what I said at the outset. Conflict. At that point, it's that litigant's problem if they have buyer's remorse. Unfortunately, I'm sorry to say it that way. It sounds kind of harsh, but the internal psychological issues that we all have, right? If you have buyer's remorse after you've been addressed with reaching terms and then beyond, what would keep you up at night? Oh, well, you know, I want that apology. It sounds silly, but I really want that. Okay, it's written in there. It's confidential. It's inadmissible. You got it. Anything else? Yeah, I really want that shoelace that he's wearing. I like that colored shoelace. And I'm not joking. I've seen that happen. Okay. Anything else? No, that's it. At that point, if there's buyer's remorse, it's not the mediator's fault. And Ms. Jacobs' question was, okay, if party litigant enters litigation session, I think you mean mediation session, with arms crossed, leaning back in chair with eyes focused on the floor, and an explicit declaration of refusal to budge from his or her aforestated litigation position, and does that absence of good faith constitute an exception to the confidential nature of mediation? The answer is no. The mediation session is still absolutely inadmissible. The contents, substance of the mediation session is still absolutely inadmissible and confidential.
But and I can unmute, and you're correct that I can and did unmute. You're correct. I meant to put mitigate mediation session. Enter mediation with arms crossed, staring at the floor, and remain silent and really just not engaging. Is that just the sign of a completely ineffectual mediator? Because
Well, I
that
think
to me says mediation didn't occur. Because you've got
so yeah. So the answer is I think, and again, I don't mean to be curt, but what it means is that the litigant, and I think in my outline, what I had mentioned is that some contracts actually require mediation, right? Like you sign an employment agreement, and if there's a dispute, first the parties, the employer and employee, agree to first go to mediation, and then if they can't reach mediation, then they agree to arbitration, right?
yeah.
A forced mediation is rarely the one that is successful. Okay, so again, I think what I had stated a little bit earlier is that if two willing parties come to the forum, and by willing meaning that ready, willing, able to mediate, ready, willing, able to resolve, there's a 93 to 97% chance of reaching a resolution, meaningful resolution. Okay.
Yeah.
There is the reluctant mediation party, the litigant or party, and if they don't want to be there, and if their body language indicates that they're just entrenched and unreasonable, then I would say that reflects more on the party. That reflects more on the party than on the mediator. Does that mean a mediation session did not occur? No, it means that it was a mediation session that occurred that was unsuccessful in reaching resolution. But that reflects on that party, that they were unwilling to be there and they were unreasonable. I hope that answers your question. Judge Jordan?
Yeah, I was going to add that what I do at the beginning of a session is frame everything. I frame it as though they're partners to a new transaction. And if they're inviting somebody into a partnership, they've got to be engaged. This is to their advantage. And if they don't want to be here, and they are forced to be here, I say, use the time to your advantage. See what you can discover. See what you can learn. See what you can impart so that they realize your strengths and their own weaknesses. And if you just sit back and don't say anything, you won't gain any advantage. So be self-serving and be involved and help yourself.
Absolutely. And I could not agree more. And I think that goes to the engendering trust issue at the outset. That and I like that word partnership. I tend to use the word engagement more, partly because many times litigants might have been, by the way, literally former partners, and I've litigated law firm breakups, right? They were literally partners. So I might not frame it in that particular situation as you're partners in this process, but you're engaged in this process, and it is an opportunity to communicate directly with the mediator, separate and apart from your opponent, and to impart, again, strengths, weaknesses, warts, whatever you want to call them, that can help surmount, overcome the obstacles that were existing prior to the time you stepped into this forum that prevented you from settling. And again, because we know that negotiations didn't work. When it was just you two lawyers going like this, talking two around, above, and over each other, that didn't work.
I jumped ahead of them and explained that there will be emotions that come up. You will think this is a waste of your time. You may already, with the opening statement I made explaining the process, you may feel that the mediator who you thought would be neutral is really working on their behalf, and you may think the other side is not negotiating in good faith. These feelings will come up several times. So this way, when all of a sudden I see the person with their folded arms and resistant, I say, you must be going through one of those moments I mentioned would be occurring. And then it's like, aha, something triggered you. And I tell them ahead, it could be something your mother said when you were a kid, and you're hearing that voice rather than the voice of the person who's here. So
That's
I
a
try to
trigger.
let it
Yeah,
all.
that's a trigger. That's a trigger. And that goes to that sometimes overriding ether of emotions and psychic, if not psychological issues that are out there. So, Judge, what you're talking about is also in your role, what you've done very, very well is to hear, listen to, if not see, as Ms. Jacobs pointed out, the body language.
Exactly.
I
I
think,
mentioned
yeah,
love, LOVE, which my wife taught me is active listening, because if you truly love somebody, you listen to the words they're saying, but you don't always know. So, O, you observe their body language, but you still don't always know. So, V, you verify. Are you serious? Are you joking? And then E, empathy. Put yourself in their shoes, not to be their therapist, but to better understand and rebut what they're saying. So,
right. So Aviva is telling me, and I think maybe all of us, I'm going to have to try to wrap up. I hope the participants maybe now understand and see why I personally feel so passionate about this forum, this process. And I call it a methodology. That word does not appear in the Uniform Mediation Act, but it is a methodology. And so, as Judge Jordan was just talking about, and as Ms. Jacobs pointed out, body language, all these indicia elements that are floating out there. The Uniform Act defines dispute. It doesn't talk about conflict and the active listening and the understanding and empathy of a party and a litigant. So I hope I've maybe imparted or convinced some litigants, some litigators, non-litigators to consider this forum, this process, and methodology to try to reach resolution. Uh, and I'm not going to talk about politics or anything else, but there's enough division, divisiveness in the world now. The opposite of love, Judge Jordan, it's not necessarily hate, it's indifference, right? I think we've heard that. So the opposite of indifference sometimes is the active listening, empathy, understanding, and overcoming and surmounting the obstacles that a person maybe psychologically is holding on to, dealing with that conflict to try to resolve the dispute. And it looks like I have hit my time limit. So
very
unless Aviva,
good.
we can take more questions.
No, thank you very much.